This may take a minute, kids, so strap in. My friend on Discord came back with the actual case. He found the case. I don't know why it was so hard to Google this thing. Like, if you don't know exactly how to find it, this is the State v. Kelly. State of Connecticut v. Jeremy Kelly. If you don't know exactly where this thing is, it is hard to find. Google's like, nah, brah, you don't need to know about this. And Google's probably right, but I found it interesting. So the general concept from the Harvard Law Review article was pretty correct-ish, sort of. So the big deal about this was, again, two people were walking along the street. One of them looked like somebody who had a warrant. The police went to stop them. They ended up chasing... Well, I know they ended up chasing Kelly. I don't know if they ended up chasing the guy who looked like the guy who had a warrant. But they ended up chasing Kelly. While they were running, a baggie of Coke fell out of his pocket. Then they catch him, and he's got another baggie of Coke on him. All right. So there's two ways they could fight this thing that Kelly can. He wants to suppress that evidence, right? First way is under federal Constitution. The second way is under the state Constitution. Now, as far as the federal Constitution, as far as the Fourth Amendment is concerned, they dismissed it really quickly because one of the things that Brendan held was that you're not actually seized until you're basically either by force or by submitting to authority, you actually are seized. So either the police catch you physically or like they turn on the lights and siren and you pull over for them. One of the two's got to happen. If you run, you're not seized until they catch you. So because he wasn't seized as far as the Fourth Amendment, as far as the U.S. Fourth Amendment is concerned, he wasn't seized until they actually caught him. The baggie of Coke fell out of his pants before they caught him. Therefore, they had probable cause to catch him because it looked like a baggie of Coke fell out of his pocket. So there you go. So they washed their hands of the Fourth Amendment. But then, because of the way Connecticut law is written, let's see if we can't get in here. Somewhere in here, they start talking about Connecticut law and the way Connecticut law has to deal with the Connecticut Constitution claim. Geisler, it's this case right here. Geisler says basically they've got to look at it. They employ a multi-factor approach. They first adopted in Geisler. The factors they consider are 1, the text of the relevant constitutional provisions, 2, related Connecticut precedents, 3, persuasive federal precedents, 4, persuasive precedents from other state courts, 5, historical insights into the intent of the constitutional framers, and 6, contemporary understandings of applicable economic and sociological norms. Why would they consider sociological norms? That's weird. Anyway, so what they got to do is they got to look at the Constitution and federal precedents. So the relevant constitutional text, it's got to be has observed the language of Article 1st, Section 7 of the state constitution closely resembles the language of the Fourth Amendment to the federal constitution. In light of this textual similarity, it's not surprising that with respect to the second Geisler factor, namely the state's precedent, we have consistently recognized that in determining whether Article 1st, Section 7 has been violated, we employ the same analytical framework that would be used under the federal constitution. Bada boom, bada bing. So they go through an analysis of Fourth Amendment law. And they end up holding that because of Fourth Amendment precedent, that officer safety says they could chase down people on the street because officer safety. And I think they were wrong. And hopefully you agree with me. If not, that's fine. I do think that they didn't look at Illinois v. Wardlow. I do still think Illinois v. Wardlow is a better fit to this. If someone takes off running from the police, then and they're in a high drug crime neighborhood, in an area that people are known to hang out to deal drugs, they see the police and they run. I think at that point the police have reasonable suspicion that crime is afoot, and they could chase them. And then if they think they may be armed, if they have reasonable suspicion they're armed, then I think the police can frisk them for weapons, specifically frisking them for weapons. All right. So you start off with Terry v. Ohio, because all these things start off with Terry v. Ohio. And Terry v. Ohio says that they can't go with an inchoate and unparticularized suspicion or hunch, but they have to have the specific reasonable inferences, right? There's specificity, not unparticularized. So that's where we're starting. Now, first they try, well, I've rearranged these into what I think are a more logical order, but, you know, bear with me here. So Brennan held that if the police stop a car, if the police by either force or by submission to a show of authority get that car to stop, everybody in the car is seized. Now, that's good and that's bad. The good thing is that passengers have a Fourth Amendment right to suppress evidence that's found in that car. If nobody grants the police the right to search the car, then the driver and the passenger probably have a Fourth Amendment protected right to not let the police in there unless they have something out in the open or whatever that give the police probable cause to search, etc., etc. The bad part is they're seized. And once they're seized, under Terry v. Ohio, if the police suspect they're armed, well, that could be bad. But they didn't get to that in Brennan. Did they get to it in Maryland v. Wilson? Maryland v. Wilson, they said, all right, we can make you exit the vehicle, even if you're a passenger. Mims, Pennsylvania v. Mims, held that the police could make the driver exit, but the police had probable cause or reasonable suspicion to pull over the car, probably because of the driver. So it made sense the driver had to get out, but did the passenger have to get out? And Maryland v. Wilson says yes. Yes, the police can order the passenger out. And then this is Arizona v. Johnson. Arizona v. Johnson is another vehicle case. They pulled over a car because they suspected it was Crips in the car. Are the Crips the blues or the reds? Reds are the blood. So Crips are the blue guys. Red v. blue. So they thought there was Crips in the car, and there was a guy in the back, and one of the cops was talking to him, and he was stupid, and he talked to her, and he told her that he was a felon and all sorts of dumb things. Don't talk to the police, for the love of God. So she gets her little reasonable suspicion hackles up, and she tells him to get out of the car, and she could do that. Remember Maryland v. Wilson? She could do that. Tells him to get up out the car, and then for officer safety, she frisks him, but she had reasonable suspicion that he might be armed, and he was already detained. Whoa, Raggy. So that's bad, right? That's bad. That's looking bad for you walking down the street with your homie, and the police think your homie's a criminal, and they could search you. That's bad. They probably can't. They probably can. Just to be perfectly honest with you, they probably can't. I just don't think the cases have held that yet. Then you got Ibarra v. Illinois. Ibarra v. Illinois is the police got a tip that a bartender in a bar was slinging heroin, and the police get a warrant for the bar and the bartender. All right. Police go in there. They search everybody, customers, everybody. They find a guy. They do the frisk for weapons, and they feel a package in one of these guys' pockets that they think is a cigarette carton, or not carton, cigarette pack of cigarettes that feels like it has lumps of something in it. So then they pull it out, and sure enough, it's heroin. And the court said, no, bro, You had a warrant for the bartender in the bar. That's it. But then it gets wonky. You got Michigan v. Summers. Michigan v. Summers, guy's leaving his home. He is outside on the front steps. He's descending the front steps, but the police have a warrant to search his home. So they're like, nah, brah, why don't you head your ass back inside? And so he goes back inside. And the police search the place, and they find heroin, and then they search him, and they find more heroin. Did the police have the right to detain him? The court said, yeah. There's already, a magistrate's already signed off on probable cause, so yeah. The police have an interest in keeping you from walking out of the house with evidence while they're searching. You probably want to be there anyway, so the police don't have to smash doors and break locks and things like that. And there's not really any more social repercussions from having your house searched with you there than with you not there. Plus, it's your house, so I mean, you really shouldn't object to being there. And officer safety. All right. So that worked. And then you have Maryland v. Bowie. I'm going to say Bowie. And in this case, it's another search warrant. And they catch Bowie coming out from the basement. And then one of the officers says, you know what, I'm going to go check down there just in case there's someone else. He goes down there and he sees incriminating evidence, a red running suit. Because apparently the armed robbery was done by two men, one of whom was wearing a red running suit. Looks bad for Bowie. He tried to suppress it. He said, hey, you already got me. You had an arrest warrant for me. So why are you searching my basement, brah? And so the court held that the protective sweep, they can do a protective sweep to make sure there aren't any armed people in there. Because God forbid they catch the person that they have the warrant to catch and then they just leave with them. Then you don't have to make sure that there's nobody else in there. Because, I don't know. That's weird as hell. I don't understand it. I don't agree with it. But that's the way it is. So from this, they say that you can search your buddy. The police can search your buddy who they don't have probable cause or reasonable suspicion to search, simply due to the fact that he's your buddy and he's near you, and they think that they have probable cause or reasonable suspicion to search you. Not making any sense to me. I hope it's not making any sense to you. Then there's Sampson v. California. Sampson v. California, they think it's the smoking gun. What was the quote that they used in it? I think I have it written down. I had some free time at work today. So in Sampson v. California, they're talking about reasonableness, not individualized suspicion. So let's see if this is actually searchable. No, of course not. What if I download the PDF?
Whoa, I can't do it that way. I'm going to do it this way. Yay.
All right. Let's see if we can search it this way. Here we go. All right. So, as the court in Lewis recognized, individual suspicion is not an absolute prerequisite for every constitutional search or seizure. Also see Sampson v. California, where they said the touchstone of the Fourth Amendment is reasonableness, not individualized suspicion. Oh, that sounds bad. I wonder what Sampson can be all about. Oh, it's about a parolee. If you're on parole, they can search you anytime without search warrant and without cause. And that's because you're still you're in the penal system still. You're out and you're free, but you're not 100% free. You're like what Bao should be right now. You're out with conditions. But I guess Bao prefers to be someone's girlfriend in jail.
He's a cute little feller.
I think Salvaggio has a fetish for Asians. Maybe if Salvaggio ever gets arrested, then it could be love. So I don't think this works. Now, they did have one other case, which you may have seen right above it, where they were going for Lewis. Lewis is an 11th Circuit decision. And I didn't have it open. The 11th Circuit reversed. Okay, District Court. They really liked Lewis. U.S. v. Lewis. This U.S. v. Lewis, I'll just tell you what it is. The cops, I think in Chicago, a couple cops walked up to a group of 4 people, and they were thinking these guys may be up to no good, and they're like, "Hey, you guys got any weapons on you?" And 2 of them stupidly said, "Yeah, we got pistols on us." So then the cops ordered them all, to get down on the ground. It was a high stress situation. They all got on the ground. Then the cops frisked them all, and they found a gun next to Mr. Lewis, under a car near Mr. Lewis. Was it his? Was it not? Who knows? Who cares? Did they have the right to tell these people to get on the ground and frisk them? The 11th Circuit thought so, but the U.S. Supreme Court hasn't said anything about it. The 11th Circuit doesn't apply to Connecticut. The 11th Circuit doesn't apply to the area I'm in, the 9th Circuit, and it doesn't apply to the 5th Circuit, which is where the Leon Valley thing was. So is it persuasive? Sure. But is it controlling? No. So if you have to go to an 11th Circuit decision to find something to support you, maybe you're stretching a little too far. Now, of note, they also talk about this case, Mueller v. Mena? Mueller v. Mena? I think it's probably an N-Y, but I don't know. So in this case, the police had a search warrant because they thought the house was a gang house. And they kept Ms. Mena detained in handcuffs for a couple hours. And she did a 1983 lawsuit because that's just unreasonable. And the court said, nope. Nope. Sorry, kids. Being in handcuffs isn't just de facto abuse or a de facto violation of the Fourth Amendment. It's not in and of itself unreasonable. So the 2 meth heads that were complaining about being in cuffs, they said they were in cuffs for 10 hours. I'm sure if you're that strung out on speed, that probably felt like 10 hours, waiting to get your next hit. Is it a hit with meth? I don't even know. I'm bad at my job. Anyway, so that's why I don't think that officer safety trumps the Fourth Amendment, even in, so under state law in Connecticut, it does. But that's under the state constitution. Federal constitution should still protect you. Should, in air quotes. But this decision, just once again, is limited to Connecticut. Their string of cases may get you to that same decision in the 11th Circuit. Maybe. May not. We'll have to see. I hope it doesn't get there. Anyway, thank you for watching. I hope you found this as fascinating as I did. Links to all these cases will be in the description. Please read them. And if I got anything wrong, let me know. Thanks for watching. Have a great day.